Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, I'm Steve Weisbrot. Welcome to the latest edition of Angeion's Leading Litigator video series. It is our pleasure today to be joined by Roland Tellis, a partner at the law firm of Barron & Budd and the head of the consumer class action practice. Roland, thanks so much for joining us.
Thank you for being here, Steve. I appreciate it.
So, Roland, you have an extensive background as a defense litigator turned class action plaintiff's attorney. Can you tell us a little bit about how that came to be in that journey?
Sure. So over the years as a commercial litigator, I got to know the law firm and its principals. We had done some matters together, and they came to me and they were interested in expanding their footprint in California. I knew a lot about the firm, and I was interested in going to a place that would give me the freedom to build a consumer class action practice from the ground up. And I think it's safe to say we both got what we wanted, and I've truly embraced the plaintiff's world.
But why consumer class actions in particular?
So after representing large corporations for many years, I thought consumer class action practice would give me the opportunity to balance my professional desire to continue to work on complex, high-stakes cases, but also my personal desire for social justice, the ability to hold corporations accountable, influence corporate behavior, and also potentially give millions of people access to the courthouse they may not otherwise have.
Yeah, that's great. Social justice issues aside, are there materially different, is it materially different the way that you would represent a consumer as opposed to a corporation in these types of cases?
So I think if we don't look at it as consumer versus corporation, but plaintiff versus defendant, I happen to think, and I've experience now tells us, that it's a lot harder to represent a plaintiff. And what I mean by that is when you start at the intake level, plaintiffs' lawyers sometimes get caught up in representing causes and not cases. We tend to fall in love with every scheme that someone comes to us and accuses a corporation of. I think on the front end, if you engage in a healthy amount of vetting with an eye towards recognizing that you have to meet the elements of a claim, we go a long way to ferreting out those cases. While the cause might be noble, the case isn't winnable. We have a saying around here, we live by that adage, it takes, you got to kiss a lot of frogs to find your prince. On the litigation side, I think we recognize that there are a million ways to lose a case when you're a plaintiff, because the plaintiff's got to win every element and a defendant just has to win one. And you've got the burden of proof. So I think experience has told me that it's harder to represent plaintiffs, and we've adjusted to that.
Do you find yourself getting blind to that, right? I mean, I remember from my practice days, one of my mentors always said, the case is going to look the best it's ever going to look the day it comes across your desk, right? And at what point, we would wrestle with, at what point did it get so bad that, wait a minute, this isn't the case that walked in the door? And what do you do when that happens?
Well, for us, it's about doing the vetting on the front end. I mean, we've come to the realization that it used to be the class certification was the event that drove a settlement, because defendants put a lot of stock in the inability of a plaintiff to get to that place, and once you were there, the exposure was too great. Today, class certification is just the beginning of a lengthy series of motions that will follow Rule 23F, summary judgment, and what's tried and true is that it's a trial date, or the trial itself, that generates the momentum for a settlement. So when we evaluate a case, it's not so much is the case certifiable as a class action, but can you win it at trial? What are the elements? And I think, of course, there are times where you're wrong about something. I mean, The evidence doesn't always pan out the way you want. The class representative doesn't always perform the way you want. We've seen that recently in trials where case had merit, but the class representatives didn't perform as you might expect. So many things can go wrong, but we tend to evaluate cases as if they're going to trial.
So what percentage of your practice do you think is MDL centric now?
Approximately half, maybe 60% MDL.
So I think just yesterday I read a report that there are now record numbers of women being appointed to leadership at MDLs, which I think everyone considers welcome news. Any thoughts as to why we're starting to see a turning point on that at this particular junction?
So I think this is just a broader issue of diversity in leadership positions, whether it's at corporations, law firms, or in an MDL setting. It's an issue that is important to me. I've done hiring at plaintiffs' firms and defense firms. I think they all suffer from the same sort of issue that I'm sure plagues corporations and cases, which I'll get to in a minute, which is there's no shortage of diversity at the entry-level positions where firms, cases, corporations fall off is at the leadership position. And whether that's because young lawyers don't see mentors that look like them, talk like them, act like them, or whether it's the absence of them in management, what have you, we tend to lose diversity as you go up the ranks. And when you go to the MDL world, I don't think it's much different. If you pay attention at a JPML hearing, not to who's in the courtroom, but to who's speaking, you'll get an indication of how we still need to work on this area.
So speaking of MDL practice, you famously petitioned the JPML panel on the opioids case. Is it everything you thought it was going to be?
Well, it's one of those be careful what you ask for scenarios. I think I spent 30 minutes with an argument that I thought was going to take 5 before the JPML panel, and I think their focus was appropriately on case management. How are we going to get our arms around what is widely believed to be the largest, most complex litigation in U.S. history? It has been all that and more. Fortunately, we have a creative judge who has sort of imposed a 2-track solution. On the one hand, we have litigation, and we've got some of the most sophisticated defendants, pharmaceutical companies, represented by some of the best defendants, putting up a heck of a fight. But we still have a trial date that's looming, and we have organized the case in such a way that I think is more of a traditional bellwether approach. And if all goes well, we'll have a trial in a few months in the first bellwether.
Wow.
At the same time, I think the court recognizes that this is one of the worst epidemics to hit our country. In the course of this interview, dozens and dozens of people will have died. And if we just follow the litigation track, it'll take years, and hundreds of thousands of people will have died. And so while we litigate vigorously, there's also an effort to try to see if there's a resolution that can be had here. It's incredibly complex because of the nature and extent of the plaintiffs involved. You've got states, you've got cities, you've got counties, you've got hospitals, you've got third-party payers, you've got people that are in the MDL, people out of the MDL. And all of that presents complexity, but some of the greatest minds in the settlement world are trying to get their arms around it. It's been a thrill for me. It's sort of, you recognize that you're on a aircraft carrier, not a speedboat. But on the other hand, you're working on an aircraft carrier, not a speedboat. So it's been a highlight of my professional life. Let's just hope I feel that way at the end.
No, I think it's great, obviously, and I think it's one of those cases that people who doubt the social utility of class actions are going to be left with, hopefully, not much ammo left in their guns at the end of the day, because this is, as you correctly identified, one of the worst epidemics our country's ever seen. So it's good work you're doing.
Thank you, Steve.
So, Roland, you obviously do a tremendous amount of consumer class actions, but even within that niche, I associate you with the MDL practice, right? You've been appointed to some of the largest MDLs in this country's history. A, do you enjoy that practice? And B, how is that different than just traditional run-of-the-mill consumer litigation?
Strangely, I do love it, including the sharp elbows world of plaintiff leadership battles, which oftentimes makes the litigation itself look really easy.
Right.
In all seriousness, for me, an MDL signifies the chance to work with some of the best plaintiffs lawyers in the country. You get to put together, either voluntarily or involuntarily, a small plaintiffs firm populated by some of the most talented lawyers in the country, all sort of rowing in the same direction. That's appealing to me. I think from a subject matter perspective, an MDL by definition, generally speaking, means you've got a fairly complex case in size and scope, and that generally brings a certain amount of complexity in the litigation, which I enjoy. And then I think because of the way the JPML panel works and how they select the MDL judges, typically you're going to find yourself before some of the most experienced creative judges in the country. And those sort of three elements, to me, make MDLs particularly, the types of cases that I try to focus on.
So Roland, you clearly have a penchant for the big, complex, socially important cases, right? We got that. Are there particular industries that you think are I don't want to say ripe for disruption, but that you target and you think you can be more effective in, places that you're really looking to make a change?
Right, so for the most part, we focus on cases against financial institutions and automakers. Experience tells us that there is a path to certification and, to be blunt, no shortage of bad conduct.
Right.
Those industries are typically populated by large publicly traded companies that have shareholder pressure to increase profits, and that pressure causes them to take some missteps as far as I'm concerned. As an example, we tend to file cases against mortgage servicers because that industry has changed, right? So there was a time when banks held the risk of default on a borrower in exchange for interest income, and they wanted to make sure you succeeded as a borrower, so they would succeed. Securitization has caused them to not care. That loan has been packaged and sold to Wall Street. They no longer earn interest income, they earn fee income, and in some ways they hope you fail because they earn late fees, repossession fees, mortgage, repo fees, whatever the case is. And that dynamic, that shift where the bank and the borrower were one-on-one and both sort of, ensuring each other's success, has led to cases where there's this desire to earn more fee income, and what that means, you've got to figure out ways to get a consumer to pay them. On the auto side, I think it's innovation. I think that auto companies are trying their hardest to become technology companies, and they've made engines more complex. They've replaced hydraulic functions with electronic functions. And at the same time, there is this race to produce as many as you can. I think last year we had the greatest production in terms of units of vehicles. At the same time, we had the greatest number of recalls. So you have this complexity of a new engine, for example, and you've got this desire to churn out more cars, and those two things lead to cutting corners at the expense of a consumer's safety. So those two areas we tend to focus on because we think there are cases out there that can be had, and there's a path to certification.
No, that's fascinating. I hadn't thought about sort of the unintended consequences of the securitization of the mortgages, right? Yeah. It really changes the face of the industry and the incentives there, which is...
Well, when you walk into your bank now, they don't really care who you are. There's a glass and there's a teller, and,
right.
And you're just a person, whereas in the old days they cared about whether you still had a job and where your family was and that sort of thing, and that dynamic has just created a bunch of litigation in that area.
Fascinating. Well, listen, thank you so much for joining us. This has been great.
Thanks, Steve. It's been good to be with you.